Good afternoon, everyone, and I hope everyone is keeping well and warm in the ever-changing weather. Thank you for joining us for this webinar. Just a really quick introduction. My name is Krishma Patel, and this is Hannah Justiva. We're both barristers at 42BR Chambers, and we deal with financial remedy cases regularly as part of our practice, along with private law cases. This talk is to give you a whistle-stop tour through preparing for a first appointment and also to set out a couple of practical pointers. It's not intended to be legal advice, and of course each case is different, but it is intended to be a short guide for first appointments based on our experience, and we do hope that it's useful. The resources used to prepare the webinar include practical law guidance, notes on first appointments and the use of experts, along with the efficiency statement and a note on the correct use of the ES2, which is the composite asset schedule drafted by the Money and Property Subcommittee of the FLPA. I'm going to start by discussing what a first appointment is and by taking you through a couple of documents that are relevant to this hearing before I hand over to Hannah. So, to start with, and to just make absolutely clear, this talk is going to deal with first appointments under the standard procedure. And that's not to be confused with the fast track procedure. The fast track procedure is used for applications where the financial remedy sought is only for a periodical payments order or for an application for the variation of a periodical payments order where the applicant is not seeking capitalisation. The fast track procedure, however, is also not to be confused with the accelerated procedure, which is going to be addressed as part of this talk. So, what is a first appointment? The first appointment is the first court hearing in proceedings for a financial remedy under Chapter 4 of Part 9 of the Family Procedure Rules. Rule 9.5.1 sets out that the first appointment must be conducted with the objective of defining the issues and of saving costs. It's commonly referred to as the first appointment or FDA. As I've said, it's the first hearing that takes place during the financial proceedings, and it's effectively a directions or a timetabling hearing to prepare the matter for the next hearing, which is the financial dispute resolution hearing, and ultimately, if the matter does not settle, then for a final hearing. At the first appointment, the court will consider what information the parties have submitted and what information the court further needs so the parties can be in a position to potentially settle the matter at FDR or earlier than that. The court will also be thinking about what directions to make to obtain any further information in line with the overriding objective, always considering proportionality. The first step in terms of the financial remedy procedure is to lodge a document known as Form A with the court in order to start the proceedings. Shortly after issuing Form A, you will receive a notice of first appointment. This document outlines the steps that need to take place before the first court hearing. Usually, this document will require the parties to conduct a market appraisal of the value of the family home, which should be jointly obtained if possible, to set out property particulars, showing what their case is likely to be on housing needs, both for themselves and for the other party, give some brief indicative material of their borrowing capacity, a questionnaire, which shouldn't exceed 4 pages of A4, a composite case summary using template ES1, and a composite schedule of assets, debts, and income using template ES2. Hannah will take you through a number of the documents that I've just mentioned, but I'm going to begin by taking you through 2 documents known as the ES1 and the ES2. A statement on the efficient conduct of financial remedy hearings in the Financial Remedies Court below High Court Judge level was issued in January of 22 by Mr. Justice Mossin and the Deputy National Lead Judge, His Honour Judge Hess, together with a primary principles document which replaced the previous good practice guide and provided templates for composite case summary and the schedule of assets and income. The FRC efficiency statement says that the day before the first appointment takes place, the applicant must file with the court A, a composite case summary using template ES1, and B, a composite schedule of assets and income based on the figures in the parties Form E, on which any unagreed items must be clearly denoted, and that is as per template ES2. So, to start with, the ES1 is a template document that can be found annexed to the efficiency statement. It allows the parties to set out basic details in relation to the background. So, for instance, dates of marriage, cohabitation, separation, date of decree nisi, duration of marriage. The document asks about the parties' incomes and whether there are any children of the family. It then asks about expert reports and whether any have been obtained. It requires the parties to set out costs incurred and projected to both FDR and final hearing. And most importantly, the second page of the document requires the parties to set out what the issues are in the case. For example, it asks whether the parties are asserting unmatched contributions, whether the parties are asserting conduct, whether the parties are seeking a departure from equality. The end of the document requires parties to set out what orders that they are seeking, along with any other relevant information. The document is intended to be agreed between the parties and is designed to assist the court to get a flavour of the case and of each side's respective positions. It's an important document that tells the court what each side consider the issues to be and whether, for example, like I've said, either party is running a conduct argument, which Hannah will deal with later on during this webinar. In terms of what can be included in the last section, which is other material information of the ES1, it may be appropriate to set out here that if any party, for instance, suffers from any disability or any health issues that impact their earning capacity and mortgage capacity in turn, and potentially their housing needs, this is relevant information that I would suggest could be included within this section. You can also include any other information that is relevant to the matter that isn't covered anywhere else in the document. The ES2. The ES2 document is known as a Composite Asset and Income Schedule. The Money and Property Subcommittee of the FLBA produced a note on the correct use of the ES2. And that note sets out that the purpose of the ES2 is to record the assets, liabilities, and income values in a simple and neutral format. And in a way, such as to enable any differences in the values asserted by the parties to be highlighted and identified easily by the court. The template was designed to limit or eliminate altogether disagreements between the parties as to how those numbers should be presented, which might cause delay to the lodging of the composite asset schedule. It ought to be considered best practice for the ES2 to travel between the parties or their solicitors at the same time as any updating disclosure is served. This will allow for the ES2 to be updated with each round of updating disclosure and therefore in advance of any court hearings. It's a document that's been designed so that the values for assets, liabilities and incomes, as I've said previously, don't have to be agreed between the parties before the document is lodged. There is a column of assets and liabilities held by each of the parties or held jointly, and that column is divided in half, allowing each party to set out within that space separately the numbers which they say make up the assets, liabilities and incomes in the case. Where there is a dispute about whether an asset exists or whether it should be included on the ES2 at all, it should nevertheless be recorded in the ES2. If, for example, there is an asset that's legally owned by a third party, but it's asserted that one or both of the parties has a beneficial interest in it, it must be recorded in the ES2. The party that's denying the beneficial interest would leave the value cells blank, and those cells would be highlighted in yellow to denote the dispute. The asserted beneficial interest in assets which are jointly owned by the parties themselves must not be recorded in the ES2. So, for example, if there is an asset such as the family home or a joint bank account and it's held in the parties' joint names, that entire asset has to be recorded in the joint column of the ES2. Again, this is a document that, when completed properly, is of considerable assistance to judges that often don't get much reading time or any reading time ahead of these hearings, which are generally listed for about an hour. I'm now going to hand over to Hannah to talk about the other preliminary documents that are required for the first appointment.
Thank you, Krishma. So Krishma set out really your two most important preliminary documents, the ES1 and ES2. I'm going to cover what else you actually need to include, because fairly frequently I do see bundles that contain, for example, statement of issues, chronology. According to the most recent guidance, despite what the FPR says, so it's Rule 9.14, in case you're interested, it does say to provide a concise statement of issues. It also says to provide a chronology, a Form G, and a questionnaire. However, Mr. Justice Peel and His Honour Judge Hess have previously been asked about this, and it's been confirmed, and it's on the Financial Remedies Journal, that you actually don't need a separate chronology and you don't need a separate statement of issues. The point being that the ES1 already has, albeit a very short and kind of basic chronology, there is a chronology there, and there is the opportunity to have that statement of issues equivalent. So your ES1 document has really superseded that requirement for those separate documents. So just facts, I hope that's welcome news, that really you only need to focus on the ES1 and ES2. Just so you're aware, although we are talking about first appointments, for FDRs and final hearings, a chronology is still required. So just make sure that for those hearings, you do produce a chronology. You also, of course, have your Form G, so that's just indicating if you can use this hearing as an FDR, or if no, it needs to be a first appointment. So hopefully that is self-explanatory. And of course, you also have your Form H to set out your costs, which is equally important. So moving on to the questionnaire, because really that's a document that is going to take significant time to prepare. One thing is obviously you need to make sure, as Krishma's already mentioned, that you are compliant with the efficiency statement. You really do need to limit it to 4 pages. There is provision that you can get permission to go beyond 4 pages, but it needs to be of complexity. So the example given in the efficiency statement is alleged non-disclosure. But really, I think the vast majority of cases can be dealt with sufficiently within 4 pages, a 4-page questionnaire. The other thing that it does mention is you need to use no smaller than 12-point font size, and you need line spacing of 1.5. There has been a string of cases and comments from High Court judges, in particular Mr Justice Peel, who's of course now taking over from Mr Justice Mostyn, in respect to financial remedies. And just to take one example, in his case last year of WC and HC 2022, EWFC 22, he said within that case that court orders, practice directions and statements of efficient conduct are there to be complied with, not ignored. Why is it fair for one party to follow the rules but the other party to ignore them? It's really important that we do follow this guidance. So you try and keep it within 4 pages, and you try not to mess with the margins and so forth. As for kind of any tips on the questionnaire, when obviously it depends on the particular circumstances of the case that you're dealing with, but I think things just to bear in mind. 1, is there anything missing? Have they not included certain bank statements? Have they not included pay slips? Are there any gaps in the disclosure? I think that's one thing you always have to bear in mind. Linked to that, are there any discrepancies? Is there anything where they say actually this is the figure in for their liabilities, but the evidence suggests it's something else? Is there anything that needs clarifying? Another aspect to consider is obviously, is there anything missing from the disclosure? Kind of more fundamentally, has an interest in a property not been mentioned, for example, or is it suspected they may have a bank account fraud or another bank account? I have seen questions phrased where it's, for example, can the respondent or the applicant please confirm if they have any other bank accounts or if they have any other interest in property? In my experience, when you have a question phrased very generically and effectively re-asking what the Form E requires you to do, judges don't permit those kind of questions to be asked, and to be honest, they're not particularly helpful, because if the other side haven't mentioned it in their Form E already, then I think they're very unlikely to then mention it if you simply ask them again in your questionnaire. If you have a client who's telling you they haven't disclosed an interest in a property, for example, try and find out, well, what property is this? Why do you believe this is? And phrase your question in your questionnaire in a very specific way, in a focused way. It's this particular asset that we consider hasn't been disclosed. This is why we believe that this asset is one of the respondent or applicant, whoever you're not representing. And that is far more likely, 1, to get a response by way of a reply, but also 2, to be permitted by the judge at the first appointment. So just think about how you word those questions. Also try and resist the temptation to put forward any questions that really are cross-examination. So classic example, they put down their income needs as something that is truly impressive. Try to avoid the temptation to say, but how can you possibly justify this level of expenditure? It's in excess of what you currently spend, or whatever it might be, because you don't need to. And the problem is, if you do only have 4 pages, you need to make sure that every question that you're asking is relevant, is important, and really counts. And you can ask counsel to deal with that and to raise those kind of issues. They're not going to be issues for the first appointment, but certainly for the FDR. So that there's no need to include questions like that within your questionnaire. Also, try and think about proportionality. Again, so often we see in the questionnaire, there might be figures in bank accounts that are quite high. There might be transfers to family members. It's trying to think of what is proportionate. As a rule of thumb, I would generally use £500. If it's less than £500, it's less likely that a judge would permit that. If it's more than £500, then they probably will. But that is not to say that £500 is a definite figure, and it really depends on the overall assets and kind of how much money is in this case. If you do have a case where it's fairly limited, I've definitely had judges go lower at kind of 250 kind of mark, but just bear in mind what's proportionate. Also, if you are seeking disclosure of documents that goes beyond the normal 12 months prior to forming, make sure you set out why and why you're justifying that, either very briefly within the question, or make sure that your counsel is fully informed for the reason, because that will need to be justified. Also, please make sure that you ask all the questions that you think you're going to need to ask in your questionnaire. Even if you put in your questionnaire, you reserve the right to raise further questions, but unless it's on the back of, for example, bank accounts that weren't previously disclosed that since have been during the course of proceedings, you're not going to be able to re-ask or have a second opportunity for your questionnaire. So please make sure it's all down. And finally, try and take a step back. Think about proportionality, think about the overall costs in the case, think about what are going to be the key issues, and just make sure that your questionnaire is proportionate. These documents can be very expensive to draft, and just try and bear in mind what's really going to be making a difference, what replies are really going to be helpful to move this case forward and go to settlement. I know Krishna's already mentioned the other directions that the Statement of Efficient Conduct says we now need to comply with, but just to emphasise, particularly given what Mr Justice Peel has said, you really do need to try and jointly obtain a valuation of, it says any property used at the family home, but I suspect normally it's just going to be that one property. If you can get valuations of other properties though, please do. Just bear in mind the wording says in the Statement of Efficient Conduct that if obtaining such evidence jointly has proved impossible, the parties should each file their own market appraisal for each property and must be prepared to explain the reason for the impossibility to the court. And the problem is, if it hasn't been done, you haven't been able to get the jointly obtained market appraisal. It just unnecessarily can irritate quite a few judges, and it's just not particularly helpful for your client's position. Same applies to mortgage raising capacity. It just needs to be brief indicative material, although I would encourage you to try and make sure it includes what information that's based on, the term, repayment figures, is it affordable, for example. So the more details you can include, the better, but you need to include something. You've also got your property particulars. Personally, I think it's quite tough to ask for property particulars before you necessarily know the financial landscape, but it's a requirement. So it's something that you need to comply with. And finally, just to emphasise, one of the reasons it's important, I would say, to comply with all of those effectively best practice guidance from the Statement of Efficient Conduct, and that you will find in your notice first appointment, is, let's say that replies are done in advance of the first appointment, but your client hasn't complied with those additional requirements for property particulars, for evaluation, and or for mortgage capacity. I think there is a risk there that the other side turns around and says, well, we would have been ready for an FDR had your client complied with those directions, and you just don't want to be anywhere near that kind of scenario. It also can really help speed things up, because if the parties have already obtained that information, it might be that the FDR appointment can be listed relatively quickly, which most parties are very grateful for. So I hope that's helpful for kind of outlining how to approach those preliminary documents. And I'm going to hand back to Krishna to deal with directions, what you're asking for at the first appointment.
Thank you for that, Hannah. At the first appointment, the court would review all of the documents that we've been talking about, consider the issues between the parties, and think about what directions are needed to now progress the matter. I'm going to deal with a few common issues that normally come up at first appointments and result in directions being made. And the first of those is questionnaires and answers to the questions. Each party, either party can raise issues with the other's questionnaire as to whether, for example, a question is appropriate, needs to be reworded, needs to be answered, etc. And the court will determine at the hearing the extent to which questionnaires must be answered and what documents must be produced. Just a practical pointer here, but it's a good idea as part of any pre-hearing discussions to discuss with your opponent any objections to questions that you have and the reasons for the same, because one, they can help to narrow the issues, and two, it may also mean that you come to an agreement with the other side in terms of wording question in a slightly different way that's agreeable to both sides. The court will therefore usually order the parties to file their responses to those respective questionnaires once the content of the questionnaires have been considered, as well as any disputes in relation to those questions. Another standard direction is a valuation of the former matrimonial home or property abroad or any other property. If there is a disagreement as to the value of the properties, such as the former matrimonial home, the court will order for there to be a valuation of it. Now, that's normally done where there is a market appraisal from an estate agent. It's normally via one party selecting 3 agents, with the other party then selecting 1, and that agent acting as the joint agent for the purpose of valuation. Where the property, however, the valuation can be carried out by a chartered surveyor, but where the property is of a modest value, it's usually appropriate to obtain a valuation or market appraisal, as I've said, from an estate agent. But in addition to property, there are other assets that may need to be valued, such as a business or a company, or a party's interest in a business or company, or any chattels. But proportionality has always got to be considered. So, for instance, the likely value of chattels are likely to be considered in determining whether or not it's appropriate to have them formally valued. So, for instance, I've had cases whereby expensive jewellery has been deemed appropriate to value, noting the likely value of the same, and therefore it being proportionate to go ahead and conduct a formal valuation of it. What other directions will the court make? The court will make directions regarding the evidence in terms of mortgage raising capacity and housing needs for both parties. So normally this will be ordered in the form of a certificate from a mortgage broker, and that will indicate the information the calculation is based on, maximum mortgage that the broker believes that the party is able to secure, the term of that mortgage, repayments that would be required on that mortgage on a repayment basis and on an interest-only basis. Evidence of housing needs or property particulars, this requires the party to produce examples of properties that they say would suit their needs, and also examples of properties that they say would suit the needs of the other party. Another standard direction that's often made is update and disclosure, and that's where the court effectively orders update and disclosure where the previous disclosure has been by way of Form E. That includes updated documents relating to, for instance, the balance outstanding on any mortgage, bank and building society statements, surrender values up to date in terms of any life insurance policies, copies of business accounts that weren't available at the time that the initial disclosure was given with the Form E, any up-to-date statements showing the CEE EV, the cash equivalent value of, it will also, the updating disclosure will also include, for instance, copies of up-to-date statements showing the cash equivalent of any pension rights, and copies of any tax returns sent to HMRC, etc. The court will also, at the first appointment, list the matter to an FDR, a financial dispute resolution hearing. And that's the next stage following the first appointment. And ahead of this hearing, the court will also order for without prejudice offers to be exchanged. And these are open offers that set out each party's proposals with a view to resolving the matter without the need, hopefully, for a final hearing. I'm now going to briefly touch upon the issue of experts in relation to first appointments. So just to start with, Part 25 of the Family Procedure Rules and the practice directions set out at to Part 25, so 25A to 25F, govern the instruction of experts in family proceedings. There are a number of things that I will say there are a number of principles that should be followed in terms of considering whether or not expert evidence is required. Firstly, expert evidence will be restricted to that which, in the opinion of the court, is necessary to assist the court to resolve the proceedings. It is the duty of experts to help the court on matters within their expertise. And that duty overrides any obligation to the person from whom experts have received instructions or by whom they are paid. No party can put expert evidence in any form before the court without the court's permission, and the expert evidence is to be by way of a written report unless the court directs otherwise. And the court generally will not direct an expert to attend a hearing unless it is necessary to do so in the interest of justice. And in making the decision as to whether or not expert evidence is necessary, the court will consider the factors that are set out in Rule 25.2, which include consideration of the issues in question, as well as the impact that the expert evidence would have on the timetable, the duration of proceedings, and the likely cost of the same. So and generally speaking, in financial remedy proceedings, wherever possible, expert evidence should be provided by a single joint expert. And that is something that can be found in Practice Direction 25D at paragraph 2.1. Where the parties are unable to agree on who the single expert should be, the court has got the power to choose an expert from a list that's prepared by both parties, and then or to set out a procedure for the selection of said expert. And that is contained in Rule 25.11, subsection 2. And now I'm just going to touch base upon when expert evidence might be required. When may this come up in terms of the first appointment? Firstly, valuation of the matrimonial home or other property. As I've said, often this is done by way of estate agent market appraisals, but there may be situations where there is slightly different property involved that does warrant a chartered surveyor, for instance, going out to value any property. So, for example, farmland property or any commercial property. There may be a need to instruct an accountant to value business interests and advise on issues such as tax and liquidity. There may be a need for an actuary to advise on pension issues. Just a practical point here, but if the cash equivalent values of a pension are fairly small, the court is less likely to order an expert report on pensions, just considering the issues of proportionality. But regard in any event should always be had to the guide to the treatment of pensions on divorce at part 6 in considering when an expert is required. And that is a guide that's incredibly helpful and gives some really useful pointers on when an expert may be required in respect of pensions. Other types of experts. An expert may be needed, as I've already said, for the valuation of a business, so valuation of business shares, if it can't be calculated in a straightforward manner. And for instance, it may be needed potentially dependent on where there is quite a complex company structure and the shares can't be valued in a straightforward manner. An expert may be needed to deal with any capital gains issues, and an expert may also be needed to value chattels, as I've said, such as jewellery. Things to generally consider when considering whether expert evidence is appropriate. First, consider whether it's absolutely necessary, given the court's duty to restrict expert evidence to what is. Assess the likely costs at an early stage and the proportionality of valuation in the context of the case. The rules do require the parties to apply for the court's permission to adduce expert evidence as soon as possible and no later than the first appointment, and that's set out in Rule 25.6. Having said that, the court may allow an application after the first appointment where there is good reason for the delay. If, for example, valuations are agreed for the purposes of an FDR hearing, but expert evidence is only required if the matter proceeds to a final hearing. The application is a formal one and must be made within Form D11 with accompanied by a draft order using the Part 18 procedure. If one or both parties, as I've said, the expert evidence should always be considered to be conducted by a single joint expert. If, however, if one or both parties are dissatisfied with the joint expert's opinion, they may wish to make an application to rely upon their own expert. But remember, expert evidence must be absolutely necessary, and proportionality must always be considered in terms of those factors when making any application for expert evidence. I'm now going to hand over back to Hannah to finish off this webinar by taking you through the arguments that are often raised within these proceedings.
Thank you. So I'm going to talk a bit about conduct arguments, and there's been a fair bit of interest around this recently. So we've had Mr. Justice Peel's case this year of Svetkov and Kairoa, it's 2023 EWFC 130. The case is interesting for how it suggests judges should approach the issue of conduct at the first appointment. It has been somewhat controversial, what Mr. Justice Peel says, but it's really important that we're aware of what the case sets out. So essentially what Mr. Justice Peel says is that the court is entitled at that stage, so at the stage of the first appointment, to make an order preventing the party who pleads conduct from relying upon it, if the court is satisfied that the exceptionality threshold required to bring it within section 25(2)(g) would not be met. So if you like, he's essentially saying that a court can say, I'm not going to give you permission to run a conduct argument at the first appointment. He goes on to say the court should also take into account whether it is proportionate to permit the allegation of conduct to proceed. He points out that, of course, whenever a party does raise conduct, it almost inevitably increases costs and diminishes the prospects of settlement, as it so often raises the temperature, of course, between parties. He also says the court needs to take into account whether the allegation, even if proved, would be material to the outcome. Now, Mr. Justice Peel says that judges can do this in line with their case management powers, so it's justified under the FPR Rule 1.4, which sets out the case management powers that the court has. But there has been, or there is some tension potentially with what Mr. Justice Peel has said, with what's said in respect of, so for example, your case White and Vince, 2015 UKSC 14, which of course dealt with the point that there is no provision within the FPR for summary judgment, and whether what Mr. Justice Peel is saying goes against that principle or not. Now, we don't really know how judges are going to respond to the guidance from this case going forward, but it's clearly really important that we're aware that it may well be the case that going forward, if your client does want to run a conduct argument, that actually this needs to be really properly set out within the Form E, so the relevant conduct box at 4.4 of the Form E, and is really clearly set out at the first appointment in submissions and counsel's position statement, because it may well be that judges now increasingly actually refuse to give you permission to run that argument. I think it can no longer be taken for granted that you turn up at a first appointment, say you want to run you want to run conduct, which of course the judge then says, well, you might be able to, but there is the issue potentially your client might have to pay a costs order, that actually you might not even get permission to run it. So what Mr. Justice Peel does say is that if you do want to plead conduct, one, it has to be properly pleaded. So within your box, the 4.4 on the Form E, he says it's not acceptable to say you're reserving your position on conduct. He also says it's not acceptable to set out a list of conduct that clearly doesn't meet the high threshold. He actually says, in his own words, such practices are to be strongly deprecated and should be abandoned. So it's really clear guidance that that is not the way to complete your box 4.4. Instead, what he says is that you need to state out to particularize what exactly are the facts that are being alleged. What's the factual matrix that your client is alleging? And then you state, okay, well, how does that factual matrix meet the threshold criteria for conduct? And then thirdly, you need to identify the financial impact caused by that alleged conduct. So it's a three-stage process, and you need to make sure within that box 4.4 that you set out very clearly how those three separate criteria are met. And again, it's just really important, given this recent case, that is set out clearly, because if it's not, it obviously raises concern that perhaps your client wouldn't even be given permission to run this argument. And we'll have to see how judges respond. But it just really reinforces the importance of making sure that everything is in order at your first appointment, so that you can deal with these issues appropriately. If you are given permission, if you want to phrase it like that, or if you do end up having directions to plead your conduct argument, what Mr. Justice Peel does say in that case is that usually an exchange of short, focused narrative statements will suffice. So those are the directions that I would certainly encourage you to be asking for, just to have some witness statements. Ideally, like say, you have them before the FDR appointment, so that at the FDR appointment, the judge can read them and give a view as to what they make of those conduct allegations and the response. And I would also, when writing those statements, just keep in mind those three different criteria that Mr. Justice Peel has set out, and make sure that is addressed really clearly within your statement. Also be prepared for the judge to put in place page limits when Mr. Justice Peel says page limits are an indispensable tool in the judicial armoury and should be deployed. So expect these statements to be limited. It can also be quite helpful, I think, if you're responding to the other party's allegations of conduct, to argue this really needs to be limited, to try and limit your own client's costs incurred just responding to such arguments. So a little bit of new guidance, if you like, in respect of how we should be approaching conduct arguments at the first appointment. The second topic I'm just going to cover on this is intervenor issues. Now, there can be all sorts of different intervenor issues, whether it's trustees, complex business assets, and so forth. But I'm going to focus on the one that I find, at least generally, is the way that intervenor issues crop up. So typically, when a third party has a beneficial interest in a property or asset which is in one of the two parties' names, or alternatively, a party has a beneficial interest in a property which is in a third party's name. So that's what I'm going to focus on. The kind of key message is that you need to really grapple with this at the first appointment. You need to make it clear that this is an issue, this is a topic that needs to be considered within these proceedings. As to who really needs to raise the issue, and arguably both parties need to alert the court to this. But strictly speaking, if you're the person saying you don't have a beneficial interest in a property or an asset that's in your legal name, you need to raise that. And then equally, if you're saying the other party does have a beneficial interest in an asset not in their legal name, then you would need to raise that as an issue. Now, the key case that we all kind of go to instantly is Mr. Justice Marsden's case of TL and ML. It's quite an old case now, from 2005. The complete reference is EWHC 2860 FAM. He sets out basically 4 directions that you need to put into, or he says you need to put into play. So the first one being the third party should be joined to the proceedings at the earliest opportunity, so i.e. at the first appointment. Directions should be given for the issue to be fully pleaded by points of claim and points of defence. You need to have separate witness statements to deal with the issue. And he also says the dispute should be heard separately as a preliminary issue before the FDR appointment. Now, although that is the guidance and that remains good law in the leading case to turn to, I think it's just important that when you are considering, you know, what directions do we want to seek at a first appointment, there are other cases that are a little bit more nuanced, if you like, in terms of what directions you should be seeking. So there's a case by Mr. Justice Mumby, A&A, 2007, EWHC 99 FAM. He said he would not wish to be quite so prescriptive, and he instead said that vigorous judicial case management in such cases is vital, but the appropriate directions to be given in any particular case must reflect the case managing judge's appraisal of how, given the forensic realities of the particular case, the issues can be best resolved in the most just, effective and expeditious manner. So he's saying that you don't quite have to follow those 4 directions so strictly. Obviously, they're ones to be considered, but you don't necessarily have to. There's also Mr. Justice Francis and Shield, a bit more recent, although still quite old now, from 2014, EWHC 23 FAM. He noted in the case before him that there was no FDR in relation to the preliminary issue. He said an FDR will not necessarily be appropriate to the resolution of a preliminary issue, I expressed the view that consideration note should at least be given to the possibility of an FDR prior to the hearing of a preliminary issue. And then we also have the more recent case from the Court of Appeal in Berbahani and others, 2019 EWCA CIV 2301, where the Court of Appeal said effectively that it depends on the circumstances of the case as to whether you actually need to join a party, whether it's proportionate to join a third party to the proceedings. So there is this line of authority running alongside TL and ML, just saying, yes, this is the case we go to. Yes, these are the directions you do need to consider. Do we need to ask the judge to do them? But you don't have to. And actually, it depends on the particular circumstances of your case. The key issue with the TL and ML directions is that they are expensive and they introduce delay, and it may well be in a lower value case. It would be much more proportionate to have the FDR in advance, and perhaps you have brief witness statements. It really depends. When I think the best way to approach it is in anticipation of the first appointment. Just make sure that you obtain as much information as you can really from your client about why they're alleging this and what evidence do they have, so you can try and give the best possible advice, because of course costs are going to be an issue if they do pursue this argument. You need to consider whether this is a small amount in the big scheme of the overall assets, or if it's actually going to make or break the case. This will potentially be the only asset for the parties to consider. You also want to try and get hold of the conveyancing file, the office copy entries, TR1. If you can in advance, you can always ask the other side if they will be able to obtain those documents if you can't yourself. If they don't provide them to you, it's quite a nice thing to raise at the first appointment. You did ask for them to try and resolve this issue in advance of the first appointment, but you were unable to do so. Or it might be that you need to have a direction to that effect. So it's just trying to gather as much information as you can to help you determine what are the best directions to seek for your client in this particular case. If you do need to make an application for joinder, it's the D11, it's the Part 18 procedure, and you just need to make sure that application is supported by evidence, setting out the factors which connect the third party with the proceedings. It will probably be fairly obvious. But just to make sure that's done. The other thing is the court can make in order to join a third party of its own motion, regardless of what you invite the judge to do. So just to bear that in mind. The test for joinder is actually fairly low. It's if it's desirable to do so. So I think more your efforts are aimed at, is this proportionate? What are the costs, risks to my client? But I think the key thing to take away is that you can't ignore it. You can't ignore the issue. You need to raise it. You need to have a plan for how you're going to deal with it going forward. So the alternative to all of those directions and all of those considerations is to use something called the accelerated procedure. It's basically an alternative to the standard procedure where you turn up at court for your, I think generally now, 45-minute first appointment before a judge. Now, the accelerated procedure stems from Schedule 4 of the FLC Good Practice Protocol from November 2019. What they actually said in that protocol is they anticipated the large majority of cases will just have the standard first appointment, and that the accelerated procedure won't necessarily be used, it will only be used in a minority of cases. When personally I find increasingly that I get instructed for FDRs where the parties were able to agree directions and use the accelerated procedure. I think the clear benefit being that it's so cost efficient for our clients. And if you can reach agreement, then there are very good reasons for using the accelerated procedure. You save the costs of counsel for the first appointment, and you can try and avoid delay and get on with those agreed directions. I think though, just one thing to bear in mind is that the issue with not having the first appointment is it can sometimes put more pressure on the FDR appointment, because it's the first time that either of the parties are coming into contact with the court and the judge and the system, and having not had that previous experience can sometimes take a little bit of getting used to at the FDR appointment. I'm not saying by any means if there's no need to incur the costs of attendance at court for a first appointment, but I think it's something just to bear in mind if you think with your particular client or with the other side's client, if it would be helpful actually to still have that in-person first appointment. Now, when might it be appropriate? As I've already mentioned, as I'm sure many of you know, it's when you basically agree directions, but it might be that you're not in a position to use the first appointment as the FDR appointment. You still need more time. Classic example, and what I often see is parties agree there needs to be a pensions report, but obviously that's going to take some time to obtain. So once you've identified that the case is appropriate to use the accelerated procedure, what do you need to do? Well, you need to do a draft agreed directions order. It needs to be agreed by both parties and signed. You also need to attach the Forms E, but you don't need to attach the attachments to the Forms E. You also do need a concise statement of issues, when just to note that the statement of efficient conduct came out in January 2022, whereas the accelerated procedure came out in November 2019. So I think there is a question mark as to whether you would use the ES1 and ES2 in any event. I think it depends on the particular circumstances. They do request a chronology with the accelerated procedure, when that should be very straightforward. It's meant to be a neutral document, very much limited to the key facts. And then your questionnaires not exceeding 4 pages. So they need to be within that page limit, and you need to file all of those documents at least 14 days prior to the date of the first appointment. I think given the pressure that courts are under, really the earlier you can file that, the better. There is the standard orders 1.3 is the draft order template that you go to when using the accelerated procedure. Just to flag, the accelerated procedure can't be used where there is provision within the draft order for further questions to be raised, which aren't in the questionnaires, that the judge can't consider and can't approve. And that's one of the issues with putting in your document provision for schedule of deficiencies or further questionnaires, just to be aware of that limitation. Or if the parties wish to dispense with the FDR appointment, although that's generally quite unusual, it does happen, but you can't use the accelerated procedure in that event. The judge should respond within 7 days prior to the first appointment as to whether those draft directions are agreed or not, or if you need to attend the first appointment at court. It's certainly something to be very aware of. As I say, it can be very cost effective for clients to use, but it also does require you to make sure you have all of those documents in advance, because otherwise, if it's too close to the hearing, you're going to miss those timeframes. So that really brings this webinar to a conclusion. Thank you very much for listening to this webinar. We really hope you find it helpful, and it's just trying to remind us, I think, all kind of what are the key things we need to cover at the first appointment, what are the kind of things we need to bear in mind, so that we can really just give the best advice for our clients and make sure that the case is from the beginning on a good track, and hopefully will lead to an assessment, but if not, will successfully go on to the final hearing and there'll be no issues later down the line. If you, this is actually the last webinar in our autumn winter series. If you want any of the recordings, they're on our website, and this recording should be up before Christmas for you to enjoy again over the Christmas holidays. There will also, with the recording, be a feedback form, and please do let us know what you find helpful or anything that you would like us to cover in the future. And thank you again for joining us.
Thank you.